Good afternoon, everyone, and welcome to our first webinar of 2017. Our topic today will be on the emerging trends of the gig economy. My name is Lillian Sheba, and I'll be moderating the webinar today. I'd like to introduce our award-winning workplace relations and employment specialist from ABLA here. We've got Lewis Izzo, Director, and Michael Rochek, Senior Associate.
Thanks, Lillian. Of course, I'm joined here today by Lewis. Hello, Lewis.
How are you going, Michael?
I'm well.
Thanks for having me here.
No problem. You can be on my show. Of course, it's our hope and intention to make today as useful as possible. So, as Lillian indicated, please don't hesitate to shoot through some questions during the webinar. We'll do our best to respond as we go through, but we do have a lot to get through, so we should probably just get going, and we will focus our attention to answering some of those questions as well at the end in more detail. So today, as you can see on the slides, there's a bit of an overview. We're going to go through the following topics. Of course, logically, we should explain for our wonderful listeners what is the gig economy. It's a term that's been bandied around a lot of late, but it does probably require some explanation. Who is a contractor and who is an employee? And we'll go through some of the legal basics and foundations in relation to that determination. We'll also look at the risks and how getting it wrong can be costly. Lewis will go through the distinction between full-time, part-time and casual employees. We'll look at some disruptive businesses that have already got a very large footprint in the gig economy, and we'll be looking at 4 major pitfalls associated with different types of engagements that you may, as businesses, find with engaging in the gig economy, and we'll be looking at the future of regulation regarding independent contracting and casual employment. So, of course, gigs are now no longer something just that a musician gets, and as you can see, via apps like Airtasker, Foodora, Deliveroo, Uber, and to some extent Airbnb, there is the possibility of short-term, on-demand work, normally via a device such as a smartphone or tablet, and sometimes others sort of usefully coin the phrase peer-to-peer freelancing.
Michael, just for the uninitiated, can you just give us a brief explanation of what some of these businesses like Airtasker are? I've not used it. I'm aware of what it is, but it'd be good if we had a bit of an idea of what it involves.
Certainly. Airtasker is probably the purest way of kind of engaging in the gig economy. It enables people to post tasks that they'd like to be completed, and those tasks can be anything from the running of errands and quite mundane things through to much more sort of higher end professional type services. Sometimes it's marketing materials, sometimes it's other areas and that really we may not have associated with making an offer to the world at large to complete a piece of work, but increasingly I think into the future apps like Airtasker are going to provide a way for businesses to really get a lot of things done. So really the gig economy, as I've said, is really refers to the growing number of workers that have discarded conventional employment on a 9-to-5 basis, in preference of working independently, as I've said, on a task-to-task basis for various parties. It's really been driven by the emergence of digital platforms linking workers to employers or contracting parties. Companies use apps and the internet to match customers with workers. And the firms have said that they do not employ the workers directly, but they generally take a commission from their earnings. And many of those operating in the gig economy have become huge, globally significant enterprises, as you can see on the slide. Uber, for example, operates around the world. The company valued at approximately 80 billion Australian dollars. And workers, particularly younger workers, are now engaging in increasingly more flexible and independent work, and that's really what they're demanding from employers. So the gig economy obviously represents a challenge to existing labour institutions and the way the workforce is viewed, engaged and recruited. At this stage, it's really early adopter younger workers that are unhappy with longer commitment to routine, sometimes unfairly perhaps labelled Gen Y employees. Really, they're the main participants in the gig economy at this stage. Increasingly, those who are unemployed or engaged in insecure work have turned to the gig economy as a pseudo safety net rather than relying on social security payments. So it is quite useful. The digital platforms enable these individuals to swiftly connect with people, find assignments, market their skills, manage various clients and accept secure payments. So virtually any task can be completed on the gig economy, from household chores to errands to transportation, delivery of food. And really, if your business is hiring or recruiting online, there's a number of areas that you need to be aware of. Most importantly, I think it comes back to the old description of who is a contractor and who is an employee, and the legal principles that underpin that. Whether a worker provides his or her services as a contractor or an employee is something that courts and tribunals determine by looking beyond the words in a contract to examine the true nature of the relationship. So, as part of that consideration, whether something is a contract for services or a contract of service to an employer will really be discerned on a case-by-case basis. Employees versus contractors. So whether a worker is an employee or a contractor is conducted by analysing the substance of the relationship between the parties, as opposed to how the documents or the parties themselves describe their relationship. And really a key case in the area, as is indicated on the slide, is Ace Insurance Limited and Trifanovsky. It was a full court of the Federal Court of Australia decision. And really the ratio, the key part of the decision was that the parties may agree the terms of their contract, but any statement by them about the character of their relationship or of their contract has consistently been held not to be decisive of the true legal character of either. So, really, what does that mean? It really means many things, and we'll go through a number of the indicia on the next slide of what is an employee, what is a contractor. But Ace Insurance is a case which is worth outlining in a reasonable amount of detail because it involves a significant number of those determinative concepts. So, Ace Insurance concerned 5 insurance sales representatives who sold insurance for a company called Combined Insurance Company. Their services were set out in a detailed contract that stated explicitly that they were independent contractors. 2 of the contractors were with the company rather than the individual sales representatives. The sales representatives generally worked in a particular geographical area, and they reported to a regional manager who was an employee of the company, and they were rewarded exclusively on a commission basis. And the court found the key element in determining whether these workers were employees was the right of the company to control the organisation of the work and the deployment of the various agents in their team in order to get the job done, sales job done. Combined Insurance also had an ongoing and really quite intensive training program that the sales representatives had to take part in. And the sales representatives were not entitled to engage anybody else to sell Combined Insurance's insurance. And so, of course, they were unable to delegate their work. And the court ultimately said that they had no real independence of action or true independence of organisation.
I think what's interesting there, Michael, is I think that in a couple of the cases, the the employees were actually engaged through Pty limited companies, so they actually had quite a layer of structural interference between, or structural kind of separation between the work they were doing or the business they had set up and that of the principal, ACE Insurance. And yet, notwithstanding that, the court pierced right through that corporate veil and said, look, it doesn't matter that they were engaged through Pty limited companies. You still engaged them and had a high level of control over what they were doing, such that they weren't their own business, they were really part of yours. And so we're going to talk about Pty limited companies, I think, in the next slide, but the reality is even that existence of a separate corporate entity doesn't mean that employers or principals are exempt from being caught as employers if the true nature of the relationship really is that of employee and employer.
Yeah, look, that's exactly right. And you know, they'll look at the true nature of the relationship rather than how they're labelled or some of the you know, whether they have an ABN or issue invoices may not or does not answer the question. So this table really is quite detailed. It's got a lot of information on it, but effectively, if you're answering yes, well, if you're positioned mostly on the left, you are probably going to be a contractor, and on the right, indicative of employment. So really, is the worker carrying on a business? Are they entrepreneurial in nature or not? Is really you know, an underlying factor that describes whether one is a contractor or an employee. So you know, as we've said in ACE Insurance, if a worker performs services through a Pty limited company, that does assist, but it doesn't answer the whole question. Are they remunerated for goods or products delivered or paid based on results? And you know, in that case, they were paid purely by commission, but that didn't determine the question as well. In totality, does the worker provide their own tools or equipment? Can often be one of the, you know, key indicia. Whether the worker determines when and how they work and when and how the work is performed. Whether they work under supervision or not. Whether they are required to obtain their own insurances, public liability insurances, you know, safety insurances, injury insurances, those sorts of things. Whether they can delegate their work to other people, other contractors. Whether the workers offer services to the public at large or simply to one contracting party, will also be, you know, really a question that answers in large part some of these cases. Are they entrepreneurial in nature, really? Whether the worker is not presented to the world at large as part of the principal's business. So part of that is, do they wear a uniform? Do they have business cards that say that they are you know, part of the principal's business? Do they hold themselves out as carrying out their own business? Whether a worker is provided with annual leave or personal leave or not, and obviously that's a pretty obvious one, but contractors don't get access to annual leave and personal leave and other employee entitlements, and whether GST is paid pursuant to invoices issued by the worker. So if you have a large majority of those characteristics being displayed in a relationship, then it will tend to suggest that a contractor, it is a contracting relationship.
And I think the one key thing about this that often does become determinative is to what extent is the principal controlling the actions of the worker. If they've got a high level of control, which you can see evidence through a number of those factors, then they're more likely to be considered an employer. If they don't have a high degree of control, then that's when they're more likely to be contractors.
And that's exactly right. You know, and courts conduct an assessment on a case-by-case basis, and it's not enough to say that in previous cases a certain type of work was considered to be a contracting relationship, and in others it was an employee-employer relationship. Each is different, and each will be looked at by the courts at the underlying reality of that relationship. Of course, getting it wrong can be costly, and employers can, employers who engage contractors or principals who engage contractors potentially through apps in the gig economy can be found out. As you can see on the slide, whether a worker is a contractor or employee is a very costly error to make. Employers can be liable for back pay of employment entitlements and penalties for contraventions of each breach of the Fair Work Act. Obviously, if it's one person wrongly characterised or categorised, that in and of itself is an issue. If it is a large team, there are multiple contractors being wrongly characterised, then all of that is multiplied out and can be very, very costly indeed, and over a quite extended period. So minimum wage, annual leave, penalties, loadings pursuant to an industrial award, super, something every business should be mindful of. And as I've said, each breach of the Fair Work Act is separately actionable, and each is subject to its own set of penalty units for the particular offence. So, it's very, very important when engaging people to get it right, and if you've got any questions, to seek advice. I'll probably now pass on to Lewis to look at the differences between full-time, part-time and casual employees that can sometimes be mixed up in concepts of contracting relationships.
Yes, the reason we're looking at this is because in order to have a good discussion about contracting and the way you engage with workers, you're really talking about what's the appropriate workforce mix generally. So rather than look at contracting in isolation, the next thing to look at is, well, how else do you engage workers? What are the other options out there? How does it work? What's the best option for you and your business? So that's why we thought it's important to look at this element as well when we're talking about new ways of working with employees. It won't come as a surprise to our listeners that there's three key types of engagements: full-time work, part-time work and casual work on the employment space. And they're the key types of forms of engagement. We've also got fixed-term or seasonal work that I'll touch on briefly, but full-time, part-time and casual ordinarily the main forms. Full-time, unsurprisingly, is where you've got employees who are working 38 hours per week. They might not be working Monday to Friday, but they are regularly working a set number of hours each week. In some businesses, it might actually be that they work the equivalent of 76 hours a fortnight, but not necessarily 38 in a week. But if it's averaged out, it usually averages out to 38 a week. You then have part-time employees who are also permanent in nature, but they're working less than an average of 38 hours a week. What's interesting when you get to part-timers is you get a lot more specific requirements in relation to their engagement. There's a lot more rules about what you can and can't do. You'll see in a number of industrial awards, there's minimum engagement provisions that talk about the minimum period of time that they must be paid for to go to work. There's minimum hours of work that they can be engaged for. And a real catch is that where they work outside of their agreed part-time hours, where they work some extra hours in any week, they can be often entitled to overtime. So you might have a part-timer working 2 days a week. If they come in and work a third day for you, even though they're well under the normal 5-day workload, if it's not done, if those extra hours aren't worked in accordance with some of the award arrangements, you can have very quickly exposure to overtime liability. And so for that reason, when it comes to part-timers, you need to think very carefully about what the rules are for bringing them on board, and are you complying with those rules. If we move forward, the reality of engaging these workers also depends very much upon the actual instrument that applies to them. So if there is an industrial instrument that applies, that will be the key influence as to what the particular employee is called. Most awards, as I said, talk about a full-timer working 38 hours a week. But you may have an enterprise agreement that says, and there are enterprise agreements out there that say that ordinary hours for full-timers are 36 hours a week, or 40 hours, 38 ordinary plus some reasonable additional. So you really need to look at what the core definition of the category of worker is under the industrial instrument. If there is no industrial instrument, you're talking about someone who is award-free, enterprise agreement-free, well, then we pretty much revert to that definition of 38 hours per week as a full-timer, less than that's part-time. But if you do have an industrial instrument that applies, that is the primary source. And that is a critical consideration when we then move into the world of casual employment. And this is a world which has been subject to a lot of disruption in a few different ways. It's been subject to disruption in the legal sense, in that the principles applying to casual employment have been radically affected in the last couple of years due to some decisions that I'm going to talk about. But it's also been disrupted in the sense that at a practical level, we have seen a huge practical change in the way people engage with. There's been a proliferation of casual employment over the last 20 years. You may have heard about the increased casualisation of the labour force. It's a real thing. There's a lot more casuals being engaged. There's a lot more labour hire companies being used to engage with workers. And then we have, with the emergence of the gig economy, a reliance now on increased use of independent contracting, which is what Michael talked about earlier. So casual employment's really at the forefront of a lot of this. There's a really interesting history with casual employment, and perhaps the best way of talking about it is to talk about how it was historically viewed and to talk about where we've come to. So historically, there were some key cases, and the primary one is one from about the mid-90s called Reed and Blue Line Cruises. But basically, the federal court has for a long time said that if someone's work is truly intermittent in nature, it's truly sporadic, it truly has variations and fluctuations, so there's no realistic expectation or no legitimate expectation of ongoing systematic hours or certainty as to what you're going to be doing on a day-to-day basis, then you are a casual employee. And the contrast of that, or the flip side, was that if you had regularity, certainty of rostering, you knew what your hours would be, and you were told that in advance, then you were someone who wasn't engaged on a casual basis, and you were much more likely to be permanent. And so in the 90s, we had these cases that basically said, if on engagement, there is regularity, certainty about what's going to be the hours of work, that kind of person, no matter what you call the relationship, that kind of person is likely to be permanent. And it's only if there's this level of uncertainty, irregularity, that they really can be casual. And it's just like the contracting relationship. Doesn't matter what the parties describe the relationship as, one looks to the substance of the relationship. So that was really the federal court authorities through the 90s and earlier, followed through the 2000s and even up to 2010 with another case called Williams and MacMahon. That kind of line of authority prevailed. It has come under extreme, I don't want to say doubt, but there's been other influences that are adapting the way the court and the Fair Work Commission are dealing with this now, though. And that's primarily with the introduction of the Fair Work Act and the industrial instruments associated with it. And we now have a line of decisions that are up on your screen, Tellem Civil, FWO and Divine Marine. And what they say is, forget all that history that I've just talked about and spent the last 5 minutes directing attention to. Forget all of that. The question is, what does the industrial instrument say? That is the primary source of obligations for engaging workers. It has statutory force, and so we give primacy to what the industrial instrument says. Now, in Tell 'em Civil, we had a case where there were people engaged on a regular and ongoing basis, 38 hours a week, in long-term jobs. At first instance, the Commissioner said, well, that looks to me like a permanent employee. It smells to me like a permanent employee. Quacks like a permanent employee. Hey, it's a permanent employee. You call them casuals, doesn't matter. And then the full bench of the Commission said, well, no, it's not that simple. The industrial instrument says you can engage casuals if you engage them and call them a casual and pay them a casual loading. That's what the instrument says. It appears to contemplate having them on a relatively long-term basis. Why can't you have a long-term casual? The Fair Work Act gives unfair dismissal rights to casuals that have been engaged for longer than 6 months on a regular and systematic basis. It doesn't say they're not casual. It just says that they can now access the unfair dismissal regime. And so they said if the industrial instrument, if under that document they were engaged as a casual and it works under that document that they can be a casual, then it doesn't matter how regular the work has been, they're a casual. And that was followed up in FWO and Divine Marine. That was a federal court case where they said, yeah, we tend to agree, at least for the purposes of the manufacturing award, with what the Fair Work Commission said in Tell 'em Civil. And again, they had in this FWO and Divine Marine case, someone that was manufacturing equipment. The manufacturing award defined a casual as someone who is engaged as a casual and paid as such. And they said, okay, so you need to engage them as a casual, that is call them one. Pay them as such, that means give them the casual loading, and pay them on an hourly rate. And if you do that, they're a casual. And there's no further line of inquiry into the other elements that were really talked about in Reed and Blue Line Cruises. So that is, what is it regular work? Is it systematic? So that's the approach that's been adopted more recently. So the advice we would give to our clients and members out there of the New South Wales Business Chamber is that you must start with the industrial instrument. That will define what is a casual. If you don't have an industrial instrument that's applicable to the employment of your staff, then you're back at that old common law approach. You're back at Reed and Blue Line Cruises. Is it intermittent work? Is it irregular? If it is, they're going to be casual. If it's not, you have a real risk that they might be permanent. And you have to do that analysis, much like we talked about with that table for independent contracting. You need to kind of look at all the features of a casual engagement typically and say, do they apply here? It's not a terribly satisfactory approach because it leaves room for doubt in each case. But that's the approach that needs to be taken if you're in a situation where there's no industrial instrument applicable. So that's the takeout when it comes to casual engagements, is that first and foremost look at your instrument and just engage the person. If you want to engage them as casual, just make sure you comply with what your instrument says about how a casual is engaged. But if there's none applicable, then you really do need to look at the substance of the relationship. Now, we're going to talk about some key issues that arise if you get it wrong shortly. But needless to say, it is important that you get it right from the beginning. Now, just before we move on to some of the pitfalls, it's probably appropriate to pause here and talk about achieving the appropriate workforce mix. Now, this is something that employers need to consider when you're looking at your workforce globally. There's advantages and disadvantages to each of the types of labour that are outlined on that slide there. The advantage to full-time workforce is, firstly, it gives the employee a level of security about the way in which they're going to be engaged. There's a level of permanency, you know when they're going to turn up, and you're guaranteed of a very regular form of engagement. The disadvantage is you have a fixed labour cost there, one which is very difficult to get rid of. Unfair dismissal provisions apply. You really need to ensure you have a regular amount of workflow coming in to service the full-time employee. Timer is hugely emerging for a whole heap of reasons. We've got it's the form of engagement of choice for for young parents. It gives people the opportunity to have flexible work. But by the same token, there's still that level of permanency associated with it. You can't change the hours without consent. You have the spectre of overtime being applied if you just get someone to do some extra hours in any particular week.
And Lewis, that actually perfectly dovetails into a question from Elizabeth S. She says, I run a bookkeeping company and we have peak periods every quarter. Is it legitimate to engage a part-timer with, for example, 10 hours per week ordinarily and 18 hours per week at peak times quarterly without it triggering extra 8 hours, that extra 8 hours becoming considered overtime?
And so that's a key example where you demonstrate the focus you need to have to, well, what's the appropriate type of engagement. It depends on the award applicable. It may well be that you've got the Clerk's Award that applies there to your company. If you change the hours of that part-timer, there is a good possibility, and I can't recall the provisions of the Clerk's Award off the top of my head, but that it will require that part-timer to be paid overtime for the extra 8 hours, unless by consent, on the week that you want to work them 18 hours, you agree that from now on, they'll be working 18 hours a week. And then by consent, you'll have to bring them back down to 10. Now, if at any point they don't consent, you've got a real headache on your hands. And if you're looking at a level of workflow that's going to oscillate, that's where part-time, at least under current award provisions, can be quite problematic. Because if you up the hours, you're looking at potential overtime if you do it without consent. And if you have then done it with consent, you've got a real issue if you then bring the hours back down and they don't want to agree to that because they're liking the extra cash. You could be facing redundancy scenarios. You could be facing breach of contract claims for not providing the amount of hours that you've then committed to. So that's where the casual workforce can come in handy. That's where the casual workforce can come in handy. You can change casual hours at a whim. That's not a problem, provided you comply with consultation or notice obligations in award. You have the ability to do that. You have the ability to improve your flexibility by bringing people on at will, taking them off at will. That's the attraction of the casual employment. There's a couple of things that feature in here, though. The first is, with the casual test case that's currently on in the Fair Work Commission, we're likely to see a possible outcome whereby casuals have a right, where they've had regular and systematic work, they have a right to convert to permanent status after regular engagements of about possibly 6 months. Some awards have these provisions already. A lot of industrial instruments have them, but there's a commission, there's a test case in the Fair Work Commission at the moment where, if it's successful, we could see all awards containing casual conversion clauses that say after 6 months, if they've been regular and systematic, they're permanent. Now, that's a disincentive to engaging casuals regularly because it might mean the advantages you struck out of casual engagement automatically then gets lost and they're back in the part-time bucket. Now, we need to see how that case unfolds, but at the moment, casual engagements still do seem to be a more attractive way of engaging a number of workers if you want to change the hours regularly. And the beauty of some of those cases we talked about before, the TLM civil cases, is what they're emphasising is there's nothing wrong with engaging a casual on a long-term basis, provided your industrial instrument allows it. So if you've got an award that you can engage them under, or an enterprise agreement that is still consistent with long-term casual engagements, then sure, go for it. And it won't be deemed an unlawful engagement by the Commission or a court because the industrial instrument permits it. However, if you don't have an industrial instrument applicable, that's where you need to be careful about engaging a casual long-term, because that's where you might see an outcome whereby a court turns around and says, well, they were never really casual to begin with. Now, one of our callers or one of our listeners has also asked, well, what about individual flexibility agreements? Are they still allowed? The answer is yes. that might be one way in which you address the hours of work with the part-timer, where you had the oscillating load. A number of the awards permit you to vary hours of work with individual flexibility agreements. The problem with them is you need to show that the employee is better off overall, and if they're not, you might have a breach arise. So that's something you need to turn your mind to. You've got to be careful with individual flexibility agreements and part-time work. Just because you enter into an individual flexibility agreement doesn't cure your issue about overtime if the employee would be better off without it. So you need to be satisfied that there's either monetary or non-monetary benefits there that put the employee in a better off overall position. But they're the kind of things you need to consider when you're talking about who's best to use. And then we've got contract labour. Contract labour is highly attractive because you don't have to worry about any of this stuff, about unfair dismissal, about changing hours of work. You can change them at a whim. Contract labour is hugely attractive. It only becomes unattractive when you end up in Michael's table of doom there from before, and you have this headache of, well, actually, are they truly a contractor? So you need to make sure when you engage in contract labour that they have that sufficient level of independence in the way they run their business to not be caught as having them or having a court turn around one day and say, oh, actually, they're really employees. And the best way of doing that is to ensure that it truly is an outsourcing arrangement when you outsource, and that truly they will have a fairly high degree of control over how they're going to do this work that you need to be done. So they're all the things you need to think about workforce mix. Most people will have a balance of all of those things that are on the table for this reason. Full-timers are cheaper. There's no loadings that need to be applied that you might have in the casual space, but they're fixed. So what people will traditionally have is a core level of full-time workers. They're often your best workers, the ones you want to lock down long-term, and then you look to supplement that with more flexible labour in the casual department. It might be cheaper in this sense. It's not cheaper from an award perspective because you've got a 25% loading, but it's cheaper in the sense that they might be people who've come on board more recently. You haven't given them the over-award pay rises. You might be giving you really good workers, and so they might be younger, more flexible staff that you're not paying the top dollar to that you're paying the full-time workers. And they're the ones you're getting to fill gaps in your workflow.
And I think it's also really in the future, part of the mix might be sourcing that contract labour via apps like Airtasker, and that's where the gig economy may expand into the way we recruit and obtain talent in businesses. So as part of that sort of flexing up and flexing down, companies may start to use things like Airtasker or other apps that may arise in the future to source specific types of contract labour.
Now, the one thing that's not on that slide, but you do need to take into account as well, is fixed-term contracts. Fixed-term contracts are a very helpful form of engagement. What they can do if they're executed properly is you can have a set start and finish date on the contract. When the employee finishes, it means you won't have exposure to unfair dismissal liability because you haven't terminated the engagement. It's ended with the effluxion of time, the courts say. So let's say you know you've got high volume coming in for the next 9 months. You might say, well, let's bring on people for a 9-month fixed-term contract. You can still have termination provisions in there. You can still terminate it with 4 weeks or 6 weeks notice. We often call these maximum term contracts. But if it's very clear that at the end of the engagement, the contract will terminate, if it's very clear that there's no expectation of renewal beyond the end of the engagement, when that contract does expire, you will not be up for liability under dismissal-related provisions because it was always envisaged that the contract would expire. And so that's why we commend fixed-term contracts, particularly for short-term contracts, 6 months, 9 months, even 12 months. Only danger about fixed-term contracting is you need to be very careful about renewing fixed-term contracts and rolling them over if you haven't put a new fixed-term contract in place before the other one ends. What we don't want to see is a fixed-term contract expiring, no one's put into place a new contract, and someone's just rolled into kept working. If that happens, we end up in a scenario where we might be looking at the employee converting to a type of permanent arrangement. Do we want to move to sham contracting?
Yeah, with one eye on the time. And we do notice there are a few questions coming through. We may be able to get to that at the end. But in terms of sham contracting, that's really, you know, wouldn't it all be simpler if instead of mucking around with full-time employees and part-time employees and casualised workforce, why don't we just label them all contractors in a way that that is sort of knowingly misrepresenting an employment relationship? And businesses need to understand that workplace relations, safety, and other risks associated with embracing the gig economy also may lead to some situations which could be you know, described as sham contracting. So really, what do we mean by sham contracting? Well, the Fair Work Act says that there is a prohibition on knowingly and recklessly misrepresenting employment relationships as independent contracting relationships, and of course, quite heavy penalties apply for breaches. So it includes a prohibition on dismissing or threatening to dismiss an individual who is an employee and performs a particular type of work for the employer to engage as a contractor performing the same or substantially the same work. That is, you have an existing workforce and you simply you know, wish to dismiss them and re-engage them as contractors. There's also a prohibition on an employer making a statement that to an individual that the employer knows to be false in order to persuade them or influence them to enter into a contract to perform services as a contractor. And businesses should be mindful that sham contracting provisions operate with a reverse burden of proof, and that means that if a person is alleged to have taken an action for a particular reason or with a particular intent, i.e. to avoid the requirements to, you know, pay employee entitlements to employees, the person is presumed to have taken that action for that particular reason or with that intent until they are able to prove otherwise. So it's quite a serious situation for an employer to find themselves in. And of course, you know, if an individual makes that claim or the Fair Work Ombudsman makes that claim, the business is put to task to prove that that is in fact not what they did. They did not knowingly set up a sham arrangement.
So moving to the major pitfalls associated with the different types of engagements, we just wanted to give you 4 key takeouts, 4 things you should always think about in this space. The first speaks for itself. We've kind of kept hammering on about it, and that's mischaracterizing the nature of the relationship. So I think that's the first, if only because we've mentioned it about 30 times already in the webinar. So that's whether you call them a casual and you get that wrong, you call them a contractor, you get that wrong. That's got to be the first, and that's what we're quite concerned about. The second really relates to part-timers, and it's this often misunderstood question about changing their hours. If you have a part-timer working 10 hours a week or 2 days a week, you just need to be conscious that you can't just give them a few extra hours a couple of weeks and assume that that's all fine. There's very strict provisions and awards about changing their hours, and indeed in many cases you might be up for overtime if you increase their hours, unless you enter into some arrangement with the part-timer to agree to formally change their part-time hours. Under the awards, the part-time hours can be quite locked in, and so you just need to be conscious of that. So that's the second takeout. The third takeout that we have is one about how you pay employees by reference to their entitlements. We're seeing more and more employers paying just an over-award rate in the hope that that will cover all an employee's award entitlements. The problem with that is, unless you've specifically identified to an employee that the amount of money that you are paying them on a weekly basis is in satisfaction of all their penalty rates, all their casual loadings, all of their entitlements under the award, it's quite possible a court will conclude, well, no, we just assume the rate you gave them, the base rate of pay for their base hours, and that there's extra loadings applicable for certain evening time shifts, there's extra penalties applicable on the weekend, and even though you've paid someone over and above their base entitlement, you won't be able to rely on that over award payment to offset other entitlements that might arise under an award. So when you're dealing with your engagements, we think it's critical that you have an appropriately drafted set-off clause in your engagement document that makes it very clear that the amount that an employee is receiving is in satisfaction of all their award or other industrial instrument entitlements. And that's a key area that many employers fall down on. So that's our third takeout. The fourth one is really this renewed focus on casual engagements. People need to be conscious that casuals do have, once they're engaged on a regular and systematic basis, they have rights you might not be aware of. Your award may very soon contain, it may already contain, or it may soon contain casual conversion provisions that oblige you to notify the employees of their right to convert to permanent status. It may be that they have unfair dismissal access. And so these are the types of things you need to keep an eye on as we move through the engagement of different forms of workers. So we fall back on this slide, emergence of disruptive businesses. You see all the pics up there. Michael's told you about these to begin with. I think, have you got a little bit further to say here before I plunge into the future of IR? Or
it's really just to set out how these apps have operated and how they have engaged staff to sort of provide the example. So obviously with the emergence of Foodora and Deliveroo in particular, these people who ride bicycles around the cities at dinner time, who may or may not be on the footpath, who may be delivering meals in their thousands by the week, have started making complaints to the Fair Work Ombudsman about the way that they're paid. Deliveroo, it's valued at approximately $1 billion, and it signed up 1,200 Australian restaurants in its first 10 months. So it's really, gives you an idea of the scale of some of these operations. Delivery drivers have traditionally been covered under industrial awards. They tend to have things in there like time and a half on Sundays, on Saturdays, double time on Sundays, overtime provisions and the like. And we know that Deliveroo has rolled out several different types of conditions to workers. Initially, the most common was the payment of $17.70 per hour plus $3 per delivery. But most riders are now opting for a $10 per delivery model. And Deliveroo says that because they operate in a compact space, contractor bicycle riders are delivering, many different meals per hour. They're saying that they're paid well in excess of any employee entitlements if they are later found to be employees. And of course, there are some unions who are very interested in the way these businesses operate, and I'm sure our listeners will probably be aware of a case called Hollis and Verboo, which was a High Court of Australia decision which effectively said that a bicycle courier that was involved in an accident with a pedestrian was deemed to be an employee rather than a contractor, despite being described as a contractor, despite having proprietary limited company, despite issuing invoices and the like. They only rode for one employer. They provided a tool of the trade which wasn't very significant, a bicycle, and they were found to be an employee. Now, Deliveroo and Foodora argue that they're correctly characterised as contractors on the basis that they have their own ABN, they may work for multiple companies, and in the same instances hold their own insurances. We know that Morris Blackburn, the union law firm, are considering class action proceedings after the success of some high-profile cases abroad, most notably involving Uber in the UK. And quickly, that was 2 drivers on behalf of 19 other drivers who argued successfully that they were employees of a San Franciscan-based firm rather than working for themselves as independent contractors. And the drivers argued that they were paid as little as £5 an hour, which is substantially below the £7.20 minimum wage in the UK. And the Employment Tribunal's the Employment Tribunal's decision was incredibly scathing. And of course, it's only the first instance, but it is quite interesting, the words that are used, and it really shuts down a lot of the arguments that some of the local operators here will be falling back on. And it really, it says Uber resorted in its documentation to fictions, twisted language, and even brand new terminology. And the notion that Uber in London is a mosaic of 30,000 small businesses linked by a common platform is, to our minds, faintly ridiculous. Drivers cannot and do not negotiate with passengers. They are offered and accept trips strictly on Uber's terms. Uber has indicated it will be appealing the decision, of course, and there are 3 more layers of appeal, or 2 if Brexit happens sooner. That seems pretty unlikely. Brexit's probably going to carry out. So it's going to go on for a while, but the words used are very damning and appear to shut a lot of doors. So it's really an interesting space to watch. So Lewis is going to take us through very briefly what the future of IR regulation might look like as all of this kind of clashes together in the one moment.
Yeah, so, I mean, there's going to be a response to these businesses like Uber, Deliveroo, Airtasker. They're not going away, and it would be quite difficult for the legislature to just kind of pretend that we can just somehow outlaw all of these types of new technology that are coming up, because they're being generated by the app world that we're now in, and that app world is not going away. If anything, it's becoming more prevalent. So there's ways of engaging, though, with this new form of work. Business likes to encourage remote working, increased ability to have individual flexibility. So from the business lobby, you hear things like, let's expand the ability to have individual flexibility agreements. There's a lot of talk about individual statutory contracts coming back, the old AWAs. We probably won't see that because the Labor Party is against them, and the Liberal Party is probably more petrified of them than the Labor Party because of the remnants of work choices. So between those 2 major political parties, I don't think we'll see individual statutory contracts back. But that then leaves a greater role for IFAs to perform and for people to individually agree what works with them. And that's only going to the need for that's only going to become greater as we have more and more people entering the workforce as part-timers because of their caring responsibilities and so on and so forth. We then have a desire in some circles for more certain regulation of independent contracting. If you recall the table of death that Michael put up earlier, it's really unsatisfactory in 2017 after hundreds of years of the rule of law, thousands of years of people bartering and trading, that we still don't have a very clear definition of who is someone's employee and who is a contractor. We still have to resort to this myriad of balls up in the air that one has to juggle. And when you go to a firm for legal advice, they'll have to say, well, look, our best hunch is that it's X, but you never really know till the court's made a ruling. That to me seems to be unacceptable in this day and age, and it may be that we need to move to a more certain form of contracting. That may be we have a definition in the Fair Work Act. It may be that I'll talk a bit more about what the union movement wants, but there's some mechanism that gives us more certainty. The other thing is in the part-time space, we're likely to see, and in the part-time casual employment test case proceedings that are currently before the Fair Work Commission, we have seen a push for more flexible part-time working arrangements. If we're going to increase the ability of people becoming part-time by having casual conversion to part-time, by restricting who can be casual, then what may need to be seen is a freeing up of part-time labour and ability to change those hours a little bit according to business needs. So that's something you'll see business pushing for. On the union side of things, unions are going completely the other way. What they're saying is, let's forget all of this debate about who's a casual, who's part-time, who's a contractor. They want to just expand the minimum safety net to all workers. So we all know about the NES and the 10 minimum standards it entails. What the unions are saying is any worker should have the benefit of that, regardless of whether they're a contractor or not. That then gets rid of their headache of who is a contractor or not, because they're expanding some of these employment-related entitlements that the unions say are basic entitlements for everyone, expanding that to everyone. Now, that's likely going to be met with significant resistance from the business lobby. The union's also saying we should have a definition of employee independent contractor. They're quite keen on this idea of the Fair Work Commission having the power to determine who is and who isn't an independent contractor. Almost like the ATO gives binding rulings on tax questions, you could go to the Commission for a binding ruling on whether someone's a contractor or not. Yet to see if that model is going to be adopted, but it's something the union movement's pushing for. Other kind of key features of the union side of the debate is they'd like to see the creation of a portable long service leave scheme for everyone, moving to a scenario where to accept or to accommodate this fluid movement of employees through multiple jobs, as we like to see more commonly, well, why don't we effectively give all employees long service leave, which effectively then just becomes a reward for being alive, because if you're alive and in the workforce, you'll get your long service leave. There is a possible business response to this. It's one that's being championed in a couple of overseas jurisdictions. Some of the Nordic countries are there already, as they tend to be on some of the more progressive stuff. And this is this notion of flexicurity. What that's really talking about is setting up a scheme whereby the business movement can almost embrace what the union movement's saying, yes, this idea of portable long service leave, great, let's take all of this stuff on board. Let's give employees, let's take the money employers are paying into things like long service leave and put it into a scheme for employees, but put them into an income protection scheme. And effectively saying, why don't we roll in unfair dismissal, redundancy, long service leave, all of the entitlements, all the money that goes towards these types of things, and set up a social safety net, which basically contemplates that people are going to roll in and out of work a lot more often. And dependent on the level of contribution that a person makes into this scheme, it could also be linked to super even, depending on the amount of contribution that goes in. When someone falls out of employment, there is a social safety net that maintains their employment. You don't have well-paid executives falling back onto the dole to sustain themselves. They can fall back onto income protection insurance that has effectively been bankrolled by things like money that used to go to long service leave, and sets up Flexicurity, basically an ability for people to roll in and out of different work more flexibly and more commonly or more regularly, but to know that there's an underlying safety net there for them. Now, this is a little bit more out there, but it is being talked about in some circles, and you won't see it going away, but it's probably more the 5 to 10 year term than nearer than that. I note that it is 1 o'clock on the dot. I think it's probably an appropriate place that we can draw a line under the sand, unless there's anything else Michael wants to add to the discussion.
No, I think we've covered it all. I'm looking through the questions from our listeners, but it doesn't appear to be a backlog at the moment. So I think it's probably time for us to wrap up.
All good.
Thank you, Lewis and Michael, for the great content. I'm sure our listeners have gained some valuable insights. It may have probably raised some questions around your flexible workplace requirements as well. ABLA would be more than happy to help you implement this. I have included Lewis and Michael's contact details, so feel free to get in contact with them directly for an initial chat. Thank you.